SJC-12289, Commonwealth v. David Lydon.
Mr. Garland, good morning.
Good morning, and may it please the court. My name is Jeff Garland. I'm representing David Lydon today, and I'm asking this court to remand to the sentencing judge for consideration of sentencing credit in the judge's discretion for the time when Mr. Lydon had been sentenced to a House of Correction sentence out of Roxbury, but was also awaiting trial in the case at bar. I understand the case law says Mr. Lydon doesn't get it as a matter of right. I'm asking for the judge to be able to give it in his discretion, as part of his discretion to give concurrent sentence generally.
Would it have been different if he didn't order the sentence forthwith?
I don't think it changed anything. I think a forthwith sentence in this case is basically just a concurrent sentence that starts right away. So, and I would cite, I think Abrams versus Commissioner I've cited says, you know, the judge used the language forthwith in that case, and they treated it just like a concurrent sentence.
And you don't believe Needle versus the petitioner already stands for the proposition that the judge has the discretion to award the credit even if there was a sentence being served?
Needle?
Yes.
I don't recall Needle reaching that specifically one way or another. I mean, almost all these cases, I think all of these cases are situations where someone is coming, often long after the fact, and saying, I want this court to make this credit happen as a matter of law, and you know, by the appellate court. And so they're not always 100% precise about discretionary versus as a matter of law credit. When they are precise about it, such as in Barton, such as in Ridge, the court has always said, yes, you can give it as a matter of discretion, but it's always been dicta because it's never been squarely before the court that way. And I think the credit is necessary, or the ability to consider the credit is necessary, because otherwise you end up with these factors that end up taking too much importance of when someone gets into court in one case versus another, how quickly does it proceed to sentencing, and these aren't the factors that should be deciding how long someone ends up incarcerated for.
Now, when you say credit, are you including the possibility of nunc pro tunc, that the sentence shall be treated as if it commenced on the date that he began serving his probation sentence? Right.
Well, I mean, that's basically the same idea, and I would say it's basically the same principle that I think we cited the Barton nunc pro tunc language in my motion to Judge Laureate below. Here it's a little funny because he actually already does get credit starting in August of 2014. Then it stops with this sort of little donut hole in between, then it starts again.
And am I correct that the violation of probation was based solely on the same robberies that he was ultimately convicted of?
I wasn't the attorney in that case, so I can't say solely. I think that was certainly the moving factor.
And was there a finding of a violation based on that? Do we know?
I don't. I never got the transcript from that. I got the docket. It just said, found in violation. But I think certainly the fact that he's committed an unarmed robbery is going to be the guiding factor. And I think that I assume that's why he's getting a 6-month sentence also on, these are misdemeanors that carry a maximum of 9 months total. And again, not being there, I can't say for sure, but my impression was that it wasn't something that there was a lot of contest about exactly how long that credit was going to be, or how long that sentence was going to be, because it was assumed he was going to be, incarcerated one way or another, whether it was on this bail or whether it was on this sentence. I've listed some of the consequences, the sort of weird results that could come in my brief of applying a rule that would prohibit this credit, even discretionarily. That it was going to matter a lot where, whether some cases in the same court or a different court, whether you're sentenced first on one thing or another. And these are factors that shouldn't be in the end determining the amount of time someone does. So, if the court has any further questions, I'd be happy to answer it.
Okay, thank you.
Thank you.
Ms. Saxey, good morning.
Good morning, and may it please the court. Hella Saxe on behalf of the Commonwealth. Judge Laureate here awarded the defendant the correct amount of jail credits he was due. He had no discretion to give credit for time during which the defendant was serving an unrelated sentence, and therefore there can be no abuse of discretion. Here, the defendant never asked Judge Laureate for a nunc-pro-tunc sentence or a sentence that was concurrent with the probation or revocation sentence, and so Judge Laureate could not decide that matter when he was never asked the question.
Wasn't it forthwith, though? Doesn't that make it concurrent?
It did not make it concurrent. No, the forthwith sentence essentially wiped out the House of Correction sentence and made it end the day he began serving his Superior Court sentence.
So the sentence effectively was, I sentence you to this on the robbery charges, which effectively is on and after whatever time you have already served after your stipulation to the violation of probation.
That is correct, yes.
Because he got credit for the time prior to the stipulation because he was awaiting trial on
Correct.
both. Are you saying that Judge Laureate did not have the authority to say that I'm going to declare the sentence to be nunc-pro-tunc as of the date of the finding of violation?
You know, had he been asked to make the sentence nunc-pro-tunc to the date of the violation, he could have ruled on that. He was never asked that question. He was only asked to give the defendant sentence credit, and that I think is indicative pages 4 and 5 of the transcript, where Judge Laureate says, I cannot give him credit for this time. It also is a fair interpretation of the defendant's jail credit motion and Judge Laureate's ruling thereon. In terms of credit, the defendant received everything he could have received. Had Judge Laureate been presented with the request for a nunc-pro-tunc sentence, I'm sure Judge Laureate would have ruled on that, but he was never asked the question.
But if you can do nunc-pro-tunc, then why can't the judge have discretion to award credits when somebody's serving a sentence? Oftentimes what happens in the Superior Court is it takes a while for somebody to get in on a plea or a request to conference the case, and they've already stipulated to a violation of probation or been sentenced in another county or in the district court, and you have actually a joint recommendation for the sentence to be nunc-pro-tunc to the time that the defendant in the Superior Court first indicated an interest in pleading. And the prosecution often supports that position. So that raises the question of, if you can do one, why can't you do the other?
Your Honor, I agree with what you said, and I think even though the effect of the two may often be the same, they are conceptually very different. A nunc-pro-tunc sentence versus amount of jail credit a defendant receives for time he spent incarcerated because he was not able to make bail. Often it makes all the sense to have sentences run concurrent, to have them commence on the same date, even though they originate in different counties, absolutely. But that simply does not encompass the concept of jail credits. And I think it is very important to keep these two separate, because effectively, if this court ruled that Judge Laureate could have given the defendant jail credit for the time he's now asking for, that would allow defendants essentially to chop away 2 days of incarceration with just serving 1 day. And I think that's not the purpose of the jail credit statutes. It's not the purpose of this court's case law, and the court should not entertain that argument. The two things are just conceptually very different, even though they may indeed have the same result in the end.
So, and I don't mean this in any way to impugn the argument. I think you make a good point, but it just isn't good optics to look like you're double counting a sentence, but if the judge feels that what is fair is to do a nunc pro tunc sentence in a particular circumstance, even though it's the same thing, that's just more consonant with what seems like an appropriate sentence in the case.
Well, Your Honor, that may be the case. Here, however, the two cases, the defendant's probation revocation on unrelated drug charges and the guilty plea to two cases of armed robbery and assault and battery on an elder, have nothing in common. Simply the defendant happened to be on probation, and there was a stipulation. It's unclear from the record whether the stipulation was based solely on the Suffolk County charges or also on the defendant's open cases in Norfolk County. Judge Goburn found the defendant in violation of his probation, and at that point in time, he had three different options. He could have terminated probation, he could have continued probation, or he could have imposed the sentence he imposed. But that is solely the discretion of the probation revocation judge. And in any way interfering with these unrelated cases, I think also goes against the guidelines Judge Fabricant issued last year on probation revocation proceedings that advocate against tracking, as is also the case in the rules on point. So I think attorneys simply have to be really precise in what they are asking the court for. And here, Judge Laureate was never asked to make the sentence non-pro-tunc, therefore he could not have answered that question.
He could not have? He couldn't have done that independently, you're saying? He didn't have
really
the
had
discretion to do that?
Well, he has the discretion to sentence the defendant in a way.
That's the point, though. That's the only question I'm asking. He could have if he had wanted to, whether or not he was asked. Asking is not critical, is it?
Well, in this case, I think it is, where the discussion, as we have it from the record, pertained to jail credits. And Judge Laureate fashioned a very favorable sentence to the defendant because he made it forthwith and essentially wiped out the House of Correction sentence 50 days before it was slated to end.
No, I'm not arguing about that. I'm just saying that if he'd wanted to do even more, he could have.
In terms of sentencing?
Yes.
Yes. Not in terms
No,
of
I understand
credit.
that. I'm sorry, talking about sentencing. If he'd wanted to do something different on sentencing,
He
he
has
could have.
discretion to fashion a sentence within the limits of the law, absolutely.
Okay.
But not discretion to award credit where none is due.
Right, so if he had given credit, you would say that's an illegal sentence.
Correct.
If he had given a nunc pro tunc, you may be unhappy, but you would not be coming here saying it's an illegal sentence.
Your Honor, I don't think I would go so far as to say it would be an illegal sentence. I would say it would be an illegal award of jail credits.
So you say nunc pro tunc equals an illegal award of jail credits and therefore can't be done? I thought that was not your position.
No, Your Honor, I'm sorry if I misspoke. I like to advocate that the concept of jail credits and of a non-pro-tunc sentence should be kept separate.
Right.
And
we're in
that's my
agreement.
position here.
Okay,
Thank you very much.
We'll take our morning break.